Hi.
Alan is a CPA who started coding as a teen and now codes blockchains. He is the CEO of TokenFunder, a Toronto-based blockchain services company, building a platform to help mainstream businesses launch regulatory compliant initial token offerings. You're going to hear a lot of words today. Initial token offerings, initial coin offerings, ICOs, ITOs, crowd sales. They're kind of all the same. I mean, there are subtle differences, but they're kind of all the same. ITOs, ICOs, crowd sales. And TokenFunder will be soon launching its own ITO. Alan is also chair and co-founder of Blockchain Canada and chair of Canada's Blockchain and DLT Standards ISO Committee. He brings hands-on technology experience as a finance and risk transformation executive at a global bank, at Scotiabank, and finance transformation management and consulting with Deloitte and PwC. And he's worked with a variety of startups. Please join me in welcoming Alan Wunsche.
Thanks, Jeff.
Next on our dais, we have my colleague Daniel Fuke. Dan is a partner in our securities and mergers and acquisitions groups, who's been closely following and writing about the development of ICOs and the blockchain space generally. He advises clients undertaking ICOs, operating cryptocurrency exchanges, and conducting mining operations. Soon also fund formation. Get ready. And last but not least, my colleague Koher Christensen. Koher is the co-leader of our financial institutions group. His practice involves advising banks, insurers, and other financial services businesses on a wide range of regulatory, transactional, and corporate matters. So as you see, we have a pretty interesting group of people coming at these issues from a variety of perspectives. I think we should just dive in. So everyone's had prepared a short presentation, and then we're going to do some moderated questions from me, and then we'll open it up to the audience, if that's okay with everybody. So, Alan, why don't you kick it off?
Thank you very much, Jeff. It was a lot of kind words there, so appreciate those. And first of all, thank you to Fasken Martineau for putting this event on. It's certainly a testament to seeing the great turnout here that it is an important and timely discussion that we're having this morning. So I'm really delighted to be here this morning, and thank you, Jeff, and the organizing team for putting this on. So first off, I was just going to say I do have a few slides, and I believe most of you either are seeing those slides on the webinar or have those slides in your possession. So I will move through a few of these. I wear a few hats. The blockchain community has evolved pretty rapidly over the last couple of years. So I've moved from the banking sector, where that's the trust business. I've got a finance background, to what I think is one of those kind of next revolutionary technologies, and many of us do. So moving from banking, I kind of dove into blockchain as the next technology on the horizon, and also have seen kind of many in the Canadian space kind of become more aware of what blockchain can do. So at Blockchain Canada, we do strive for awareness, education, influence in terms of where Canadian corporations and startups can take this. We're we're connecting many Canadian entrepreneurs and innovators. So those are a lot of grassroots meetups we've been holding, and they've been a lot of fun. So a lot of great people are showing up, and great to see this audience here this morning. So thank you. And finally, yes, Canada is involved at the ISO level, which is technical in nature, and that's Technical Committee 307 for some of the geeks in the audience. That's the Blockchain Standards Global Initiative at the ISO level. So I do chair that, and delighted to kind of be at the Canadian level. So excited, and let's dive in, because for a little bit of context, if I may, this is a great slide from the World Economic Forum, which really positions blockchain, or DLT, as another term that's synonymous with blockchain in many cases. Distributed ledger technology is one of the handful of technologies really that are about to transform, some may say disrupt, our financial services infrastructure. This was a particular financial services slide. Every industry is getting impacted, but as you can tell, there are a number of kind of factors all coming together at the same time. We're speaking specifically about blockchain and DLT, obviously, today. That's a really big one. And the World Economic Forum predicts, actually, that within 10 years, and this is important, that we'll get at least 10% of the world's GDP on blockchain technologies. So it's coming, it's here, it's coming quickly. And an important note to add, for those of you kind of getting a flavor for what the technology is, it's open source technology to begin with. So this is not your proprietary typical traditional financial systems technology. This is open source, which gives a lot of new flavors to the discussion we're having. Okay, so Gartner puts out these hype cycles, and I've used them to kind of set some context on many occasions. I used to only use the July 2016 one until recently, and you'll notice that in the space of only a year, we've moved from almost peak hype on the left-hand side to the right-hand side, where we're starting to come down the curve. There's some reasons for that. In 2015, we saw the emergence of the banking industry consortia, so there was a lot of hype around that. 2016, we saw a lot of proofs of concept, and now, as we're in 2017, we're beginning to see actual implementations. For example, RBC yesterday advised us that they had been working on a shadow ledger that works against their primary ledgers. But these are live implementations now in the financial services sector. And Gartner obviously, gives us a forecast, and they believe that 5 to 10 years we'll actually go through that trough of disillusionment and actually have sustainable business in the plateau. So many believe it'll be sooner, but we're at that stage now where we're coming off. In most cases, we're coming off hype in the corporate space anyway. And moving into, first we'll see a disillusionment happening off that hype, but then we'll come into reality. Okay, so why is this important? And what has been the journey for us to get to where we are today? Won't go into any technical kind of features of this, but we began with a story in 2009 when the financial crisis hit and Bitcoin came on the scene. So Bitcoin was pretty much dismissed. It was designed to be a peer-to-peer digital cash from the outset without any banking or financial services intermediation. So it would be a peer-to-peer digital cash, and it was described as the Internet of Value. So we're moving from our first generation Internet of Information to now being able to immutably and securely send a Bitcoin, in that case, or a token of digital value between individuals through the blockchain platform. Okay. Now blockchains communicate through to one another through the internet, but I mean it's a layer that sits as a peer-to-peer layer, and this is the public blockchain. So Bitcoin being the public blockchain. And it was the first blockchain. Fast forward to 2014 when Ethereum came on the scene, and 2015 when it became live. Not too long ago, Ethereum comes on the scene as a next-generation blockchain, really now a version of programmable money, because you can take software code, put it into the Ethereum blockchain, and now you can program the way that the money moves around. So Bitcoin, you transferred the money peer-to-peer, and there were some add-ons to making that a little more robust, and they continue. But Ethereum came out of the gate and said, okay, so if it was the core team that said, we believe we can actually make this programmable, and they did. In 2014, there was Canada's first token offering, or ICO, from this Canadian-based group. And that's an important part of our Blockchain Canada story, is that Ethereum began in Canada. So let's not forget that. They had an $18 million token offering, or initial token offering. We never called them that back then. It was a token sale. So in 2014 that happened. In 2015 the platform went live. Now we've got a form of programmable money, and this is now when things get really interesting and kind of magical, because you can program these smart contracts, they call them, and we get into the legal realm of that we connect the legal and the tech now. These smart contracts can be programmed to move this digital native token on the Ethereum platform, which is called Ether, and we're still talking about a public blockchain sense. And it allows us for decision making for now further forms of crowdfunding and many different kind of applications, including supply chain management, many different applications around the world. We're going to focus particularly on the tokenization. So in terms of terms, because there are many terms, and we find this at the standards level, cryptocurrencies and tokens, digital currencies, largely refer to synonymously, using this sort of similar terms. So cryptocurrency, Bitcoin's a cryptocurrency. Ether on the Ethereum platform is a cryptocurrency. And we also call Ether the native digital token of the Ethereum platform. Okay? So here's where it gets interesting. So 2015, Ethereum has its $18 million crowd sale, which was arguably the largest crowd sale in history at the time. And we'll park one topic here, and that's the fact that Ethereum started here, moved to Switzerland for a variety of legal, taxation, regulatory reasons, and became a Swiss foundation. So today, you look up Ethereum, and it's referred to as a Swiss foundation. And we'll talk about that potentially in terms of the legalities. We now have since 2015 seen a new type of funding model come onto the scene. So we have top corner there, or the top black one, Tezos. We've got the Kin token that was recently in the news, and many of you know, it's a Canadian company. Also had its token sale recently. Filecoin is the one in the blue, and Bancor. So in terms of dollars here, what are we talking in terms of dollars? Bancor about $250. Filecoin, actually Bancor was $150. Filecoin was in the $250 million range. Tezos also in the $230, $250 range, all depending on the conversion rates at the time. And Kik announced that they had about $100 million raised. So now we've got a new fundraising kind of platform or approach in this space. And working on the to be announced in short term. A little bit of a plug, but TokenFunder will have an ITO, and I'll talk about that shortly. So, what's interesting here is that these are permissionless ledgers. Anyone can open an account on these ledgers when they're public ledgers. And these companies, Tezos, Kik, Filecoin, Bancor, they went out and they used the public Ethereum platform to raise their funds. So a little more context. The CoinDesk does great work in terms of putting together state of blockchain reports. The Q2 alone shows on this particular slide how the funding through ICOs has actually exceeded the funding on the venture capital side. So this is really just a beginning, and we've now totaled about $2.3 billion to date. And this has literally happened in the blink of an eye in the last year, that we're up to cumulatively blockchain token funding, token sale funding of about 2.3 billion to date. Forecasts are that it'll be easily 4 billion in no time. So this shows no sign of stopping. All with the caveat that there are regulatory concerns throughout the world, as you may have seen, that China recently put a stop to this, and even Singapore overnight decided that they were going to put a halt to certain ICO matters. And there's some reasons around that, which we'll get into in the discussion, I'm sure. Okay, so a little more. Without going into the technology per se, a little more context and behind-the-scenes look at how this works, because it's really magical how it works. And you just start along this journey, because if you pick up from where I started before, we've got this worldwide. Call it a common good now that's been unleashed to the global community, called Bitcoin, called Ethereum, and there are other platforms that are taking their place here, or taking their place on the stage. But I'm picking up Ethereum because Bitcoin and Ethereum are the two big ones in the space right now. The first step in here is this piece in the middle called a token. And these tokens aren't just one set of digits or something that you can move around. In the Ethereum case, and we talked about it being programmable money, this is actually software code. So this is a really interesting and powerful part of this technology, is that we call it a token, but it's really software code that's doing something. And a software code in itself has the ability to become a token holder register. So, in the case of equity shareholder registries, you can hold inside this program itself the account addresses of token holders. So it's automatic. It comes with the functionality, the way that you program it. And there's a standard called the ERC20 token standard that's been around for a couple of years and has been really adhered to make it really compatible. So we've got a compatible standard, and that's a starting point for our token discussion. And it also has transfer functionality if you consider the liquidity aspect of these tokens. So transferring from one person to another, from one account to another, and a certain amount of governance. So you can't transfer more than you own, and these things are just inherently built into the code itself. So this is the magical aspect of this continues because the token itself can hold native digital token value. It can hold Ether. So not only does it accept Ether, it can move Ether, it can also manage this token holder registry. This is not just a set of numbers that we think of as a token. This is actually some magical code. Now, once you install this token onto the blockchain, it has its own address, it has its own identity, and you see how investors can then also play on the Ethereum blockchain, and they have an account. If an investor has an account on the Ethereum blockchain, they send their Ether without really regards to asking anyone in this simplified case. Sending it to the token, and the code handles it all, understands who you are and how much it received from you, and registers you and does anything else you choose to program into it. So what's interesting here is that you've got a direct connection from, let's call them investors, to, and they could be called token holders, again, terms that we're using and the terms that are new in this space these days, token holders, and some are even called contributors, but that's the nuance of this discussion. Contributing to the token, and that business then has access to the value in the token and has access to other information. We have, and on the public blockchain, there's a certain amount of transparency and auditability in this. Now, you'll notice that I didn't specifically call out any banks that are involved or exchanges in the traditional sense. You do need to get for converting Canadian dollars into your choice of digital currency, such as Ether. You'd have to convert that at a digital exchange, which are new. But you'll also notice that we now have a mechanism that a business or project, and this is what's happening. These projects don't have to go hat in hand to Silicon Valley to say, we want that first round of funding. We want, our first round. They go the token round, and the token sale is direct to those that are contributors or investors on the blockchain. So we've seen this described as a disruption to venture capital. We've just seen it described in those terms. And I should add that deep down into the details, you'll find that some venture capitalists are getting onto this and getting involved. For example, they got involved in Bancor and Tezos, and it's not gone unnoticed. We've even seen accelerators in the Valley like Y Combinator muse about how they're going to use this new funding mechanism. So really, really magical. There's some key concepts to kind of understand, and then we layer on this entire legal discussion, which is then very interesting to all of us in the space. And I won't steal my co-panelist's thunder on that. Here's a little bit of a shameless plug. This is a journey for all of us in the space. And when we saw this, in 2016, being in the space, we kind of saw this about to break open. So myself included, and some others, but as soon as the OSC's Launchpad started up, we wanted to make sure that Canadians weren't left behind, and so we brought ideas, and then this project that turned into a business startup that I'm now running called TokenFunder to the Launchpad, and it's as a learning journey for everyone in the space. There are differences between doing a quote-unquote unregulated initial coin offering, which you can do or which have been arguably done in Switzerland, in other jurisdictions, in the Caymans, in Gibraltar, in unregulated jurisdictions, and we wanted. We had a vision for building something that really would stand the test of time and would be, described as safe, now called regulated, with some of these really innovative kind of investment and governance aspects of these smart tokens. So we're going to do an ITO of our own. It's going to be regulated. It's going to be a security. It's going to be these things. It's going to happen soon. I can't, unfortunately, talk too much more because we're still with the Launchpad, but it's exciting. I'll just say one thing: the discussion does often center around whether your token, is what the functionality of the token is. We're going to get into that panel. The one important thing that the bankers all understand is KYC, know your client, know your customer. A lot of those unregulated ICOs, they don't really do KYC, and therefore they're called unregulated because they don't adhere to our view of what KYC is for investor protections. And I guess this is where kind of my story and my journey has taken me, because coming out of the finance and CPA space, we see what healthy capital disclosure and healthy capital markets provide, and I also see this as a massive innovation. So how can we bridge the two? And certainly certainly excited to be talking about this space and the innovation happening in it. I think we'll be there. We were concerned. We were very concerned that Switzerland was becoming Crypto Valley, and Switzerland was going to take the lion's share of all of this kind of future investment. I think the concern should remain that we need to be competitive. We need to continue to kind of push the boundaries and our competitiveness on a global stage, really demands us to look at what these innovative models are and how can we make them work for us in the Canadian space in particular, because there's some Wild West activity going on. As I say, Switzerland, Caymans, Gibraltar, other places. But how do we do it right in Canada? I've been doing a lot of thinking about this, and happy to talk to anyone that's more interested in all of that. And thank you very much for the time for these introductory remarks. I look forward to hearing much of the legal discussion and getting in on it. Thank you.
Alan's last comments actually lead very nicely into what I think Dan is going to talk about. We do live in the Wild West. We live in the Wild West to some extent here because the regulatory regime, the law has not caught up with the technology. I mean, I think that's the bottom line. And so what's going on, and I think Dan will address, is trying to take existing concepts and existing legislation and regulations and apply them to something that they never contemplated. Like, nobody who wrote this legislation had any idea that something like this might happen. And so you're trying a little bit to put a square peg in a round hole. The Launchpad, for those of you who aren't familiar with it, is an effort by the regulators across Canada to invite fintech startups in, and they'll help you navigate the system and make suggestions on how you can modify your business or gain exemptions, if possible, from some of the regulations because they just don't make sense or apply. But it's a process. And, I mean, perhaps somebody will ask later of Alan about his experience in terms of time and energy, because that's really the competitive issue, right? How quickly can we act? Money's leaving. There's a flight of capital to all these other places. The regulators here say, the right things. We want to be leaders. We want to do it. But where are we? And so that really is a very good segue to what Daniel's going to talk about. So, Dan.
Thanks, Jeff. And yeah, I agree. It is a really good segue because my part of the presentation is going to relate to securities laws and how those are going to apply to blockchain companies, and to, in particular, I'm going to focus on ICOs since it's such a hot topic. But I also plan to discuss investment funds and a little bit about cryptocurrency exchanges as well, and how securities laws are impacting those areas. And as Alan mentioned, the terminology that is being used is kind of, there are a lot of synonyms out there. I've chosen to go with ICO for this presentation because I thought it would be the most easily understood by the most people. But I know that there are some who think that ICO is kind of a bad term to use because it's too similar to IPO, sorry, and it makes it look like a security. But if you'll bear with me, I'm going to use ICO and also talk about about tokens or coins. So as a lot of you know better than us, this has been going on now. These ICOs have been going on now for several years. The first one that I'm aware of was in 2013 by Mastercoin. But over the summer, really, some mainstream attention started to get paid to the space, especially in and around the DAO token and how the SEC came in and shut them down. What's interesting about that, right from the outset, is that, sure, the SEC came and they looked at the DAO token and they said, yes, this is a security, therefore it must be regulated as a security. But, the reason that it was on the SEC's radar is that there was a hack of a wallet for, I think, about 50 million US. And as a result, I think that that's exactly the kind of thing that's going to put these issues on a regulator's on their radar. And so that's one thing that really kicked off the regulatory discussion. So the key question for ICOs and how securities laws will relate to them is, are the tokens that are going to be issued in the ICO, are they securities? And will they be regulated as securities? And this is, of course, important because if a token is going to be regulated as a security, all securities laws will apply. And this can be time-consuming and expensive. And difficult as well. I mean, securities laws can be stringent, and there's a lot that an issuer is going to have to pay attention to if they are issuing a security. For example, they're going to have to file a prospectus or issue tokens on an exempt basis. For example, selling only to accredited investors. And by doing that, you're shrinking the marketplace to who you might be selling to, because you're cutting out retail investors who don't qualify as being accredited. And also, if a token is considered a security, the sale is going to have to be effected through a registered investment dealer. You can't just have any old promoter out there, touting these investments and saying how great they are, because the regulators in Canada, but everywhere, are going to want to know that proper procedures are in place in terms of promotional activities. So when does the law say that a token is a security? The definition of security in the Securities Act includes some very obvious asset types like common shares and bonds, but it also includes a concept called investment contracts. And it's this concept of investment contract that's being applied to tokens. The leading case in Canada is from a case called Pacific Coast Coin Exchange. And this test actually resembles the Howey test from the US quite a bit. And some of you may be familiar with that one just because, the market in the US being larger than Canada. I think there's been a lot of discussion about, what fits the Howey test and what doesn't. A lot of that can be applied as well to Pacific Coast. So the test says that for an investment contract to be a security, there has to be first an investment of money, second in a common enterprise, with an expectation of profit to come significantly from the efforts of others. So if a token has all four of these characteristics, it will be regulated as a security. And so we've got this four-part test, but as you can imagine, there's a lot of argument that could be had within each of those four prongs as to what they mean, especially as they relate to any asset, but in particular as they relate to tokens. So what have the regulators said? Well, in late August, the Canadian regulators came out with a fairly comprehensive staff notice, CSA Staff Notice 46307, cryptocurrency offerings. And in it, they said that certain tokens will be considered securities and that securities laws would apply. And unfortunately, this doesn't tell us much that we didn't already know. Because, of course, anything that is a security is going to be a security. Whether you call it a token or whether you call it a share, if it has those features, the form is going to, the substance is going to trump the form. And I think that everyone in this room would agree that that is the correct way to apply a law. So the staff notice wasn't so helpful in that regard. I mean, it was good to know that the regulators are thinking about, how investment funds might be impacted, how exchanges might be impacted, and also reiterating that, they're going to be looking at things through the lens of the Pacific Coast test. But the real question, in my opinion, is how those four prongs of the test would be applied to tokens. So the general concept is that there's a spectrum. And at one end, we've got assets that are very obviously a security, like a common share. And at the other end of the spectrum, we've got, tangible physical assets that are very obviously not a security. And somewhere in the middle, there's going to be a line, and we're not exactly sure where this line is going to be. It might be different for every token. But on one side of the line, you've got a security. On the other side, you don't. And so I'm going to go through some of the things that we think would be really applicable to that analysis of where a token fits in on that spectrum. Sorry, went a bit ahead there. All right. So the first thing to consider, and Alan touched on this a bit, but you have to consider the function of the token. The reason for this is, how can something be an investment contract when it's really intended to be used, functionally? The CSA staff notice actually acknowledged this, and what they said was that they gave an example of a token that allows you to play a video game. And so they said if a token allows you to play a video game once, for example, and then the token expires or is burned up, then they don't think that is likely to be a security. And I think this goes to the expectation of profit aspect of the test. I mean, how can you have an expectation of profit when all you're allowed to do is play a video game? I mean, the expectation is that you get to play the game, not that, like a common share, like you can sit back, wait for some dividends, hopefully some capital appreciation, and that's what you're looking for out of that investment. Second, you have to consider the maturity of the platform on which the tokens are going to be issued. And the question here is, when is the platform going to be ready for use? Is the platform ready to be used on the day the tokens are issued? Or will the proceeds from the token sale be used to build out the platform? And this goes to the last prong of the test about the profit coming significantly from the efforts of others. So if the issuer is still building the platform and using all of the ether that comes in from the crowd sale to build their platform, then the token that you've got initially doesn't have much value. And you are relying on the issuer to create that value through the efforts of the issuer and not the token holder. And so I can see how the regulators would consider that to be a security, because it's very passive at that point. You're relying on the efforts of others to create a platform where the token will eventually have value. On the other hand, if the platform is fully developed on the day of the token sale, and you're allowed to enter into the platform and use the token immediately upon receipt, then I think we move away from the security designation. And another aspect of this that is helpful, and I've seen some tokens where the token gives the right to access a platform, but also gives the right to kind of maybe create, make changes to the platform, contribute, vote towards the development of the platform. Like, are we going in one direction versus another? Or to even sell products through the platform. And in those cases, I think, again, we move away from the concept of security, because what's creating the value there is how the token is being used by the holder, as opposed to a passive investment where the token holder is relying on the issuer to create the value in the token. A third consideration is how the token is marketed. If an issuer is marketing these tokens very broadly to anyone it can reach, touting the liquidity of the token, touting the future value of it, then I think it definitely moves closer to the securities end of the spectrum. But on the other hand, if the issuer is only marketing to people that it thinks will be the end users of the token, and it's not talking about things like future value, not talking about listings on exchanges, then we move further away onto the non-security end of the spectrum. And, I just mentioned secondary market, and that's the fourth thing that I wanted to bring up. You have to consider what the issuer's plans are for the secondary market. Of course, regulators' main goal in all of this is to protect investors. And so, a robust secondary market comes with risks. The risks are that the investor doesn't know what it's buying, doesn't know the true value of it, can go onto an exchange and be subject to a pump and dump scheme or to other bad actors manipulating the market. And to be fair, this is exactly what regulators should be doing, is to protect unsophisticated investors from exactly this type of behavior. And so I expect that regulators will be looking very closely at how an issuer is talking about what kind of secondary market there will be. So if the issuer is saying, oh yeah, we're going to be listed on all these 5 exchanges, we're guaranteeing liquidity, that kind of thing, then I think that's something that the regulators are going to be concerned about. And this even kind of moves out of the substance of what the token is, but I definitely think it's something that the regulators are going to be looking at in terms of investor protection and wanting to be involved when an issuer is promoting a secondary market heavily. And I guess one final point on that is that this takes away, discussion of a secondary market really takes away from an issuer's argument that the purpose of the token is to have a function. Because, we go back to the video game example. If the purpose of the token is to allow you to play a video game, why does there need to be a secondary market? I mean, why do you need an exchange for it? You can just play the game, or if you choose not to play the game, you don't, and the token expires valueless, much like other assets that aren't securities. All right, so let's move on to some ICOs that have actually happened and what those can tell us about what regulators are thinking. I mean, you're probably thinking now about some of the particular tokens that you're aware of, and you're thinking, well, that token doesn't fit within those 4 prongs of the Pacific Coast test, and that token has some of the exact features that you just said would move it more towards the non-security end of the spectrum. And you may be right, but it's really hard to tell right now because, like I was saying more earlier about the CSA staff notice, it didn't get into how regulators might apply those 4 prongs of the test to the particular context of tokens. And furthermore, CSA hasn't given us any examples of tokens that are not securities. There may be some out there that have gone to the launchpad privately and gotten a ruling that that this is not a security. We're going to be hands off in this case, but that hasn't been publicized that I'm aware of. And on top of that, we've only got a couple of examples where the regulators have come out and said, okay, yes, this is a security, and we're going to go through some of those examples right now, but we don't have much in terms of the reasoning behind it. So let's start with the DAO. Mentioned the DAO a little bit earlier. This was a U.S. case, and because of the hack, it got onto regulators' radar screen. And so the SEC reviewed the features of the DAO token and concluded that it was a security. Now, this was actually a pretty easy one for regulators to conclude on, in part because the promotional materials for the DAO tokens made claims that the tokens were going to be just like a common share. And there were dividend rights, there were rights to revenues that were very similar to a dividend on a common share. So this was an easy one, and that kind of opened the regulatory discussion and kind of set a baseline along the spectrum that if you have features that are very similar to a common share, it will be a security. But then that leaves a lot of gray area in terms of the rest of the spectrum. So in Canada, we've seen 2 examples now where regulators have revealed some of what they're thinking in terms of how to apply the Pacific Coast test. The first is Kik, which I'm sure you're all familiar with. Kik launched a token called KIN, which was envisioned as a general purpose token for use in services like chat, social media, and payments, all within the KIN platform. And the second Canadian example is Impact. And Impact's MPK tokens were designed to allow holders to purchase goods and services from like-minded merchants in the impact economy, again, within a kind of dedicated platform or ecosystem. So in both cases, the tokens had clear purposes. They had uses beyond just speculative investment. Yet in both cases, regulators determined that they're securities. Now, the regulators granted some exemptive relief to Impact in order to facilitate transfers within participants in that platform. And the OSC also said that they were willing to grant certain exemptive relief to Kik, but instead Kik chose not to offer in Canada, so that issue kind of became moot. But what this tells us is that having a clear purpose, that first aspect that I talked about earlier, that's not enough. So if you have a clear purpose, but you have other features that resemble a security, you still might be considered to be a security and subject to securities law. And unfortunately, we don't know what other factors will be considered in each case and how they'll be weighed. But I definitely expect that the four factors that I talked about earlier will go into any conversation that you're going to have with regulators about whether or not what you're creating is a security. I'm going to move on now and talk briefly about investment funds. So this is another securities law area that's been heavily impacted by blockchain technology and by cryptocurrencies. And the securities analysis here is actually much easier than with tokens because the fund companies that have started to operate have made it clear that they want to create, traditional investment funds where assets are pooled and, a portion of that pool is allocated to the investors. But, what's unique about these or what's new about these is that the asset class that they're investing in now is the cryptocurrencies. And so these managers, these funds are going to have to deal with the securities law implications of being an investment fund, and those include that they must be managed by an investment fund manager, that the securities that they're issuing will have to be issued pursuant to a prospectus or issued on an exempt basis. And what's interesting about the exemptions that might be available is that there's a prospectus exemption for offering memorandum offerings where the offering memorandum fits within a set form within the Securities Act. It's got standard disclosure that everybody has to include, but that is not available for investment funds in most jurisdictions, including Ontario. So that puts investment funds back in the situation of either having to have a prospectus or issuing only to accredited investors, or finding another exemption. But the whole purpose of an investment fund is to sell broadly. So the prospectus and the accredited investor are really the most likely avenues that our investment funds are going to pursue. So far, we've seen First Block get registered as an investment fund manager in BC and launched a fund for accredited investors. And they had an OM. But this is not an OM that allows you to sell to retail investors. This is an OM that just kind of describes the product, and it still has to be sold to accredited investors or otherwise to exempt purchasers. So there is a distinction in types of OMs. We've also seen Evolve launch an ETF, which of course is going to be listed on the TSX. So that's a new area of regulation that will be grappled with in the coming months. First Block's fund is going to invest only in Bitcoin, and Evolve is going to seek exposure only to Bitcoin. And what's interesting about this limited exposure is that First Block only just became registered as an IFM. And the BCSC put a number of terms and conditions on their registration about what they can and cannot do with their fund. And one key piece of that is, for now, they're only allowed to invest in Bitcoin. So if they in another cryptocurrency, they're going to have to go back to the regulators and get approval. And so we are starting to see regulated funds invested in cryptocurrency, but only Bitcoin. And it's the most easily understood cryptocurrency for now. So we still haven't seen a fund that invests in a basket of different tokens and tries to diversify against risk. These are more or less probably going to be buy and hold, and probably watch the market. Of course, any good manager would, but not try to diversify across tokens. Other key regulatory concerns that came out of the First Block terms and conditions are the regulators were very concerned about the custodian of the Bitcoin, who's going to be holding the Bitcoin, and it's going to be a firm called, I think, Xapo. Might be pronouncing it wrong. It's XIAPO. And so they have, I'm sure that they were working closely with First Block to satisfy the regulators that they are safe enough that investors' funds can be held on a custodial basis by Xapo. There are also concerns about what dealers are involved in purchasing the funds and or sorry, not the funds, the Bitcoin. And First Block was given an exempt market dealer registration so that they could do that. And also there are issues about valuation. I mean, there are a lot of exchanges on which Bitcoin trades, and so getting an accurate valuation is going to be difficult because if the manager is buying and trading from a number of exchanges. And speaking of exchanges, I'd like to say a couple of things about cryptocurrency exchanges before I finish. So the staff notice said that as of that date, no exchanges had become registered or exempted from registration. And the question of whether tokens are securities is very central to exchanges as well, because if an exchange is only offering or only listing assets that are not securities, then that really moves it outside of the realm of securities regulation. So what have exchanges been doing in order to address these issues? Well, I know that there's one exchange, and I expect that many others are doing this as well. I know one exchange is asking issuers to provide a legal opinion that the tokens are not securities before allowing them to list on the exchange. And I don't know where these opinions are coming from, because that would be an incredibly difficult thing for us to do in Ontario at this point with the amount of information that we have at this point. So, but I mean, that is the type of thing that exchanges should be doing if they're concerned about inadvertently letting securities onto their exchange and running afoul of regulators. Might be premature to have that requirement in Canada, but that is definitely the kind of thing that they'll be thinking about, I'm sure. Another option would be only allowing accredited investors to trade, and that way you can be sure that any tokens that were issued as securities would be, tradable among those accredited investors. And one final thing that I want to say about this is a note of caution for exchanges. Coinbase in the U.S., I think a leading exchange, has gotten themselves involved. I don't want to say in trouble, because I think they would take a dispute with that. But they have gotten involved with the IRS in that the IRS has been requesting a lot of user information from them. The IRS is coming at this from the perspective of trying to guard against money laundering and proceeds of crime, that kind of thing, but is trying to get at it through the exchange. And so far, the exchange has been reluctant to share that information. But I mean, I can't imagine that Coinbase is thrilled to be involved with the IRS. So just a note of caution that that tax regulators may look at exchanges as havens for bad actors and may try to make life difficult for those exchanges. So in conclusion, I mean, those are the big issues that I see in how securities law is impacting the blockchain world. And look forward to questions after Koher's presentation.
Thank you, Dan. One of the things that we're not addressing today, although some of us may be able to speak to it peripherally, is the whole tax implications of all of this. Dan talked about the IRS. I'm sure CRA is busy thinking about this and looking at it too. And I just, at this point, want to say there are significant tax implications involved in all of this. We could probably do another one of these sessions just focused on some of the tax issues. Anyhow, I'd like to turn the mic over to Koher. Koher is going to look at this from a financial services perspective, anti-money laundering, regulation as a money services business, and so I'll leave it to Koher.
Thanks, Jeff. So you just heard about securities regulation and how that applies to cryptocurrency. So I'm going to talk a little bit more generally about how cryptocurrency fits into the regulatory regime, specifically the financial services regulatory regime. And the first topic I wanted to touch on was the question of whether or not cryptocurrency is money. This is, I think, a question that gets asked as a matter of sort of theoretical interest, but there are also some legal and statutory dimensions to it. So, I think what's important to understand at the outset, and I want to make sure everyone's got the common understanding, is the difference between what we call fiat currency and cryptocurrency. So fiat currency is the official currency of a state, so Canadian dollars, U.S. dollars, etc. And cryptocurrency, I think we know what that is. But there's a fundamental distinction, which being that cryptocurrency is not the currency of a government. The Currency Act is the statute in Canada that makes Canadian currency fiat currency. So the Currency Act has a provision that says Canadian currency is legal tender. People are required to accept it. This is what makes it fiat currency, and other states have similar legislation. The Currency Act also has a provision that requires that contracts and transactions that involve money or the payment of money be carried out using either Canadian currency, the currency of another country, or a unit of account that's defined in terms of national currency. So what the Currency Act is basically saying in this provision is that, in effect, cryptocurrency is not money because it's not fiat currency. Now, moving away from the specific piece of legislation that we have in Canada and looking more generally at what money is, in terms of economic definitions, money is considered to have three key characteristics. I just want to run through these and talk a little bit about how they apply or don't apply to cryptocurrency. So number one, money is a medium of exchange, meaning that it has to be widely accepted among individuals and businesses. If we look at Bitcoin or other cryptocurrencies, it's clear that this is increasing, but I think most people would agree we're not really there yet. If you have Bitcoin and you want to buy something, you need to find someone who wants Bitcoin. And so in some senses, it is more like a barter system where, if you have a goat and you want to buy something, you better find someone who wants goats. And money is fundamentally dissimilar to that, right? But I don't think Bitcoin's there yet. But it's obviously much more widely accepted than it was at prior points. Number two, money functions as a unit of account. So it allows people to compare the value of various goods and services, right? So we can say this house costs $2 million, this loaf of bread costs $4, and people understand what this means, and they can make sense of relative values using this concept of money. Again, you can price things using cryptocurrency to the extent that there is some sort of active market or a seller who's willing to sell it for that price. But I don't think that cryptocurrency can really be said to be functioning as a unit of account in a really meaningful way at this point in time. And the third characteristic of money is that it's a store of value. And the idea is that people need to be able to assume with some degree of confidence that there's going to be some stability in value. And again, we've seen pretty significant fluctuations in the value of a lot of cryptocurrencies. So this one's also a bit of a challenge. So I think there's kind of two key takeaways in my mind when we look at this definition of money. One is that I don't think cryptocurrency is really there yet. But the second one is that I don't think there's any reason in theory why it couldn't get there. I think that if a cryptocurrency, one or more cryptocurrencies became more widely accepted, if values stabilized over time, and if they just became more commonly used, there's no reason in theory that it couldn't meet these three criteria. So I'm going to turn now to just some fairly high-level comments about the views of the government on cryptocurrency. So there was a report in 2015 from the Standing Senate Committee on Banking, Trade, and Commerce about digital currency. Now, that's 2 years ago, which is, I think, a lifetime in the world of cryptocurrency. A lot of the things that we've been talking about today were in their infancy in 2015. But nevertheless, I think that this report has some conclusions and recommendations that give us some useful insights into what the government's thinking is. So I think it's very interesting that the first recommendation coming out of the report was that the federal government, in considering legislation and regulation in this area, should foster an environment that create an environment that fosters innovation and exercise a regulatory light touch. So I think one of the key takeaways from the report is that cryptocurrency and also blockchain the technology that underlies it present significant opportunities. I think that the view is that there's significant opportunities for the government specifically in terms of how it might be able to use these technologies for its purposes, and more generally there's significant opportunities for the Canadian economy, and you don't want to stifle those. The next recommendation I want to just touch on is up on the slide here. It's the third one, which is that digital currency exchanges, so places where you can buy or sell digital currency with real money, with fiat currency, should be subject to anti-money laundering and anti-terrorist financing legislation. And I'm going to get into that a little bit later on when I talk about AML, how AML laws apply in this space. But obviously, the thinking was that AML is a significant issue here, and needs to be these kind of businesses need to be brought within the scope of that regime. The report also identified some key risks relating to cryptocurrencies. So the key risks that they focused on were, number one, the use of these currencies in the furtherance of illicit activities, and obviously probably most people know that. I mean, the history of Bitcoin is to some extent tied in with illicit activities. There was scandals such as Silk Road, where people were selling drugs, murder for hire, this sort of thing, and the payment was in Bitcoin because of the anonymous online nature of it, and so that's that continues to, I think, be a concern of the government. And a second key concern that was identified was the exposure of the public to losses relating to cryptocurrencies. And I think that there's a couple different areas where they thought losses might come from. One is the fact that there is a criminal element dealing with these kinds of assets. Number two, the risk of bankruptcy of businesses that are in this space. And number three, and this is the kind of concern that Dan is really focused on, which is the volatility in the value of these assets. So losses by buying Bitcoin high and finding out that you can only sell it low. So I'm now going to talk about the anti-money laundering regime in Canada and how it applies to cryptocurrency. So the Act, and the key piece of legislation in this place is the Proceeds of Crime, Money Laundering and Terrorist Financing Act. And this Act applies to people that are on a list in Section 5 of the Act. And one of the entities or types of businesses that's on that list is money services businesses. Okay, I just want to run through the definition here. So it's persons and entities engaged in the business of foreign exchange dealing, of remitting funds or transmitting funds by any means or through any person, entity, or electronic fund transfer network, or issuing or redeeming money orders, travelers, checks, or other negotiable instruments. So let's not worry about that last part, but I do want to, I'm going to pick up on the two underlying pieces here in a minute. So just foreign exchange dealing and remitting or transmitting funds. There is also an amendment to this Act that is not yet in force that would extend the definition of money services businesses to include persons and entities dealing in virtual currencies. But that's not in force right now. So the question right now, if you are in the cryptocurrency business in some way, is are you a money services business? And that question, I think, really turns on, are you engaged in foreign exchange dealing, or are you engaged in remitting funds or transmitting funds? So the first, I think, observation to make is that if you are in a business that involves buying or selling cryptocurrency, you are not considered to be foreign exchange dealing. The view is that means foreign exchange dealing means buying and selling fiat currency. So U.S. dollars, Canadian dollars, pounds, what have you. But if you are selling Bitcoin, you're not foreign exchange dealing for the purposes of this legislation. But there are still some ways that you can get caught. So I'm going to run through a couple scenarios here, and these are not just kind of hypothetical scenarios. I mean, these are scenarios that the regulator FinTrack has been asked about and has given views on. So the first scenario is let's say that your business involves someone coming in with fiat currency, let's call it Canadian dollars, and then you sell them Bitcoin. And then let's say you buy Bitcoin back from that person, but you do that transaction for U.S. dollars. So this is buying and selling Bitcoin, which, as I said a minute ago, isn't caught. But in this particular scenario, what the person's done is they've come to you with Canadian dollars and they've walked out with US dollars. So this would be considered, or certainly could be considered, a foreign currency exchange. So I think, if you're in this space, you need to be careful about how you're structuring your activities to make sure that you're not doing this. Now, I think there are some questions about where the line is. I mean, if someone comes in one day and buys Bitcoin with Canadian dollars and then comes in 6 months later and sells you Bitcoin for US dollars, does this fall into this scenario? I mean, arguably those are two completely separate transactions. But nevertheless, it's something that people need to be aware of if they're in this kind of business. And then let's turn now to the second scenario. So this scenario is that someone comes in with fiat currency, call it Canadian dollars, and they say, I want to send Bitcoin to someone else, a family member in some other country. I want to send them money. So they come in with Canadian dollars. It gets converted to Bitcoin. The transfer is done as Bitcoin, right? So the transfer of money is done using blockchain, and then the person on the other end gets cash, gets fiat currency. Whether it's Canadian currency or whether it's whatever their local currency is, the fact is, in this scenario, what you've done is you've transferred fiat currency from one person to another person. It was cryptocurrency in the middle, but from the perspective of what went in and what came out on the other side, it was fiat currency. And so, in this scenario, the regulator would take the view that you are in the business of remitting or transmitting funds. Okay, so the point of this is really to say you're not squarely caught right now if you're in this kind of business. Although there is that proposed or there is that amendment that's not enforced, they will catch you. But there are still ways in which you can fall into this legislation. And then another way that you can fall into this legislation is that in addition to money services businesses, it also applies to people that are authorized under provincial law to engage in securities dealing. So we just heard a lot from Dan about how securities laws apply or might apply. So if you're engaged in some cryptocurrency related business, and as a result you're required to be registered with the OSC, you're now a securities dealer for the purposes of the proceeds of crime legislation, and so you're going to be caught in that capacity. So that's another way that you can fall within it. I don't know maybe what degree of familiarity people have with this legislation, but I think it's important to understand that if you are caught by AML legislation, that's not an insignificant thing. So if you're a money services business, you have to register with FinTrack. That's in and of itself not that big a deal, but you have to have a full-blown compliance system. So you have to do client identification and other types of customer due diligence. You have to do transaction monitoring. You have to do reporting of suspicious transactions and certain other types of transactions. There's record keeping. There's risk assessments. There's policies and procedures. There's the appointment of a compliance officer. There's a lot. Financial institutions have significant departments that are focused on this. So it's intensive from a resource perspective, but it can also create major challenges in terms of the business model, right? The key thing is that AML legislation, at the very heart of it is the idea that you have to know who you're dealing with to make sure that you're not dealing with people who are trying to launder money or finance terrorists. So in other words, you cannot do business with people on an anonymous basis. That's like the first principle of it. And that can obviously be a challenge for a lot of people that are in the cryptocurrency space. Okay. The other one is that you need to identify your clients. The legislation does have mechanisms that allow you to identify people without being face to face. You don't have to have someone there presenting a driver's license. But those mechanisms, those non-face to face identification mechanisms, are at this point cumbersome. I think they're not the kind of mechanisms that would allow you to just instantly identify someone who's on the other end of a computer using some biometric system or retina scan or something like that. Like these are going to be cumbersome depending on what your business model looks like. Another thing that I just want to talk about in the context of AML is that even if you are not subject to AML legislation, like let's say that you're just buying and selling cryptocurrency, and you're not doing any of those things that are noted on this slide that would bring you within the definition of money services business. And let's say you're not required to be registered under securities law. So you're outside of it. So you might think that you're free and clear, but I think the reality is that you may find that you're running up against AML legislation anyways. So to the extent that your business requires you to deal with the non-crypto, non-digital financial system, you're going to be dealing with people who are subject to this legislation. So if you have fiat currency and you want to do something with it, you want to put it in a bank account or you want to transfer it to someone using the banking system, you're going to be dealing with banks or other financial services providers that are subject to this legislation. And what the rules that apply to them are going to say is, you need to take a risk-based approach to your customers. You need to make sure you know who they are. You need to make sure you know where the money comes from. So you might find that you are not able to find a bank that wants to deal with you, or that you're not able to find a bank that wants to deal with you unless you can show them that you, in fact, are basically doing all the things that you'd have to do if the AML legislation did apply to you. So that's a practical issue that people in this space definitely run into. The last thing I would say is that this is definitely an area that the regulator is focused on. So there was an article in the Globe and Mail earlier this month where there was an access to information request, and they got a bunch of information from FinTrack that showed what their thinking was relating to blockchain. And I think they regard it as a serious challenge. And they regard it as a serious challenge for two reasons. The first is because of the anonymity that is inherent in how some of these blockchain transactions or cryptocurrencies are currently set up. So as I said, anonymity is a major problem from the perspective of AML regulation. And the second thing that they see as a problem is the fact that this allows for transactions that are outside the regulated sphere, right? So this allows for payments, transfers of money, transactions that do not involve banks or other regulated intermediaries. And so I think their thinking was, well, I don't think that they have necessarily figured out what that means in terms of the response, but I think they've figured out that a response is necessary. And the last thing I want to touch on, just in related to AML, and this is just an information piece for people who might be in this space, is that in Quebec there's a Money Services Business Act, and what it basically it says between the act and some policy statements that have come out from the AMF is that if you have a machine that lets people use cash to buy virtual currency, you need to be registered. So I highlight that because there are similar money services registration businesses in the federal legislation, but they don't generally apply to cryptocurrencies right now. So, if you're in this space and you have an ATM type machine in Quebec, exercise caution. And that's all I wanted to say about that.
Thank you, Koher. Thanks to the panel. Thank you. So I don't know about you guys, but I have so many questions. I also have a bunch of questions that were sent in when people registered. But before I ask my questions, I just thought maybe I'd turn it over to the audience. You people look like you're just ready to ask a bunch of questions. So do we have any questions from the audience? Yaron.
With regards to the analogy of a video game, if there's a long lineup for that video game and somebody at the front is willing to sell their video game token at a profit to someone further back in line, does that then make that video game token through security?
Okay, I know exactly what you're getting at with that question. It's a very good one. I mean, there are secondary markets for all kinds of assets that are not securities. And so yeah. I mean, the mere presence of a secondary market, in my opinion, cannot make something a security. But it definitely contributes, and it will be more about what type of secondary market. I mean, if the video games become listed on an exchange, and the developer of the video games is putting out information about how great they are and how you should invest in them, maybe the analysis changes a bit. So no, I don't think a secondary market alone can make something a security. but it's a contributing factor, and the nature of the secondary market and the promotional activities also need to be considered.
Roseanne?
Thank you for a great, sorry for the voice, but thanks for the great presentation. Jeff touched upon the flight of capital. And we're talking, what I get from you guys is there's a lot of uncertainty here in Canada, maybe in the U.S. What can we do to prevent the flight of capital, the registration of new businesses in a brand new economy? Because we see this as an angel organization over and over again, and these companies are being formed overseas now. And we are losing money, losing mines, losing companies and opportunities. How fast do we need to act to gain a competitive advantage?
I'll hit on that one first. So thanks for the question, and I think this is at the heart of our challenge, frankly, because we know it's happening. It is happening at a rapid pace. We saw the numbers. We're seeing the flight of capital for sure happening. Now you got to ask yourself: is it being done the right way? Is it in a way that is it in a way that's still safe for investors? Because our investor capital is going to other places out of Canada, and are they being done in a safe regulatory way? Frankly, it is the Wild West out there. So there's a lot of tension. I mean, I'm absolutely, I want to see the innovation happen. I want to see us move quickly here. But we have to do it right as well. So it's not an easy question. It's got so many dimensions because you're clearly don't throw all of the great aspects of healthy capital markets out the window. That's an important piece of this. And you want the legitimacy of really strong capital markets, but you want the innovation here. So where do you draw the line? You certainly want these businesses starting here, and we need more clarity. And the clarity that comes as quickly as we can get it is certainly something that we'd be that I'd love to see. And I think I'll just make this comment. I think we've heard Dan and Koher talk about the changes. Our regulators are getting it. They're getting it, and we've gone through I'd say a very quick learning curve, and I can speak from experience that the level of understanding is now really high, and there are regulators that really understand that we're in this kind of competitive global race for capital. So I can assure you that those discussions are happening. I mean, I don't speak for them, but I can tell you that that tension is absolutely at the heart of this discussion.
The one thing to remember as well is that the securities issue really is about protecting residents of Ontario, right? If you do your crowd sale, ICO, ITO, and you're not raising money from Ontario residents, the Ontario Securities Commission has nothing to say about it. Right? And that's why you're seeing the flood. And that's why you saw Kin just ban Canadian investors. They didn't want to go through the time and effort of getting a prospectus pulled together. They figured it's the tail wagging the dog. There aren't that many Canadian crypto investors. And so the market is global. But you saw what happened when China banned it. The Bitcoin and Ether and all the rest of it went crashing down. It recovered. But, we're going to see that because the regulators are trying to figure this out worldwide. I mean, it's not just a Canadian problem. It's an American problem. And other regulators are all talking about, Singapore's talking about it, China's talking about it. I'm not so sure about what's going on in Switzerland, but, this is a global issue. Alan, I'm just curious, can you share with us a little bit about your journey with the Launchpad? Like, how long is it taking? What's it look like? I mean, I'm sure people will be curious about that.
I can share certain aspects of it, and I can tell you that first of all, I think this is hopefully going to be a one of a kind, and we're gonna see.
Once they're finished with you, they'll have
once
figured it all out.
We're going to see learning. No, they figured out a lot. Okay, but we did start as soon as the Launchpad opened last year. Started talking, and the could just imagine any organization that has new technology, in its space now, has to get up very quickly. And to look at it from last November, call it, to today, that's a long journey. It's a long journey of discussion, of looking at what's the right thing to do if you want to do this in Canada. We could have gone to Switzerland many times over. We could have done it externally. We wanted to do this in Canada, and we wanted to do it in a way that would deliver high quality results. That means now an intense amount of education and discussion as to which securities regulations could apply. How might they apply? Might there be exemptions to what we have? And so I know it's public in that Impact got some exemptions. We spearheaded many of those discussions, frankly, over the journey that we've had, and it's been very positive as we've experienced it. That the reaction is, we want this to happen. We want to do it the right way, and I'd say, did I want this to go on this long? Did I envision it to go on this long? No, absolutely not. I had hoped, as any entrepreneur in the space right now, that it would be just a few months. It wasn't a few months, and on the flip side, what's great about this is we have seen now those examples worldwide that we can learn from. That we can take those learnings and say, that's actually not the best example of how to do it. We're going to do it. We're going to do it in a way that makes sense in a way that the financial system in Canada survived the crisis because we had prudent behaviors, because we had certain fallbacks in place, et cetera. So even as a banker, I didn't appreciate all of this, frankly. That the banker turned technologist. I've always been a technologist in a sense, but and as someone trying to build a business, I didn't appreciate it as much. And I got we received quite a bit of guidance, frankly. So the journey has been positive, not as timely as I had wished it might be, and that's just a journey of pioneering, of trying to do something new in the space. And so I must say I get it. It's a roller coaster ride, and on the plus side, we're going to have something that is legitimate in terms of being regulatory minded. I mean, I forget the regulatory, but investor friendly, investor safe, because the journey includes this, sharing the fact that I've participated in ICOs. I can send my ether to Switzerland, to these ICOs, and frankly, I know very well that they know nothing about me. Did I mortgage my entire house on this particular project because I so believed in it and put every single, everything I had into it? They don't know anything about me when I go abroad. We've got a system here that the guys have explained this very well. That we do have an investor protection mindset. So I'll stop there. I mean, these are all elements of the journey, though. As in many fellow entrepreneurs that are in the space are experiencing the same thing. And while on the surface it looks like there are very onerous considerations, I would just say stay with it.
Jason?
There was like about 8 words that was pretty interesting to me. That was just like that purchasers of these tokens could also be held liable. So it was one sentence, and I was just interested. So if you have like the 99 accreditors that come in on, like in the U.S., you're allowed 99 accredited investors, and then all of a sudden they have instant liquidity that essentially sells them to the average investor. Do you have any thoughts on that?
Actually, I don't recall that that particular piece of it.
Like it was like one sentence that maybe the purchasers. Not
But are you saying that a group of accredited investors are buying it for resale to
Yes,
retail
exactly,
investors?
exactly, immediately, and then so all of a sudden they have instant liquidity. And there was also in that an original SEC document just like one sentence that said that purchasers could be held liable as well. I don't know if there's.
Well, I guess what we do know is that if you're going to offer them in Canada, offer securities on an exempt basis, you also need, generally speaking, an exemption to trade them on. And so that is something that is concerning about liquidity, because if you do an exempt token sell only to accredited investors, those accredited investors may be stuck with those tokens if they can't find a way to liquidate them. You need to find another exemption. You need to find another accredited investor. You need to find an exchange that is, listing them, because that's again part of the investor protection aspect, that the regulators don't want a security to be issued and then right away issued legally to a accredited investor and then immediately turned around and sold to a retail investor. So there is a big concern about liquidity from an investor perspective. Absolutely. If you are purchasing what turns out to be a security and you purchase it on an exempt basis, you may have trouble getting rid of it.
In book entry, but how do you, something that's all just done by ledger, how do you stop it?
That's a big problem for regulators, period, because it's all anonymous. The only way they can see it is if it goes through an exchange or some other entity inside their jurisdiction, and then they get them to be a reporting party. Otherwise, it's not transparent. Right. So the regulator, at this point, it's unregulated and it's a problem. But if they find out, then you got to live with the consequences. I think, the take home for me in thinking about all of this is that if you want to live and raise a family in a jurisdiction like Ontario or the U.S. or some of these other jurisdictions, you have to comply. Because if you get caught, it could be very difficult for you. The penalties, the fines, etc., are really expensive and can make life miserable. So there are people who are global citizens who have no problem going to Singapore or going to Switzerland or going to Caymans or going to Barbados or all these other places. But if you want to live and work here, you want to raise your kids here, you have to comply, because otherwise you're going to be one of these casino guys that are living in Costa Rica and can't come back to the United States or Canada. So you have to comply if you want to live here. If you don't care about Canada or the U.S. and you're prepared to, be a vagabond, you can do whatever you want. I mean, it's true. And that's, I started my comments at the beginning about the anarchists and libertarians versus the incumbents, right? That's the tension that's going on there. If you had somebody who was more libertarian-oriented, we were on a panel back at 111 at part of Elevate TO, and there was a fellow there who I would characterize as being on that end of that spectrum, and he'd just say, well, they won't know, and they can't tell, and screw them. And that's fine if you want to run that risk, but it's a risk, for sure. Nick, sorry. Okay, so let's start.
Thank you so much.
Sorry, we'll get to you. Sorry.
For an amazing seminar this morning. I had a couple of questions regarding, especially when it comes to the investment funds. Why is the OSC and the other regulators solely looking at Bitcoin and not the other cryptocurrencies? And also, with your second chart at Gartner, if I look at this from a technical perspective, and I wanted to go short these securities, the liquidity is critical, and especially within an ETF perspective, what would that bid ask look like, etc. If you guys know how to answer that. Thank you.
Sure. So the first question about why is it limited to Bitcoin? I think it's because for now, I mean, I expect that the managers would have liked the ability to, invest in a wider range. But, from their perspective, maybe it is more consumer friendly to go and, launch a product that invests in a cryptocurrency that everybody knows at this point. So that's one thing. It may have been partly marketing. From the regulatory perspective, I think that it's issues like custodial issues, like how secure are these wallets, exchange issues. How can we be sure that that this fund is going to be able to get in and out of these investments? Now, Bitcoin has proven itself to this point to be fairly liquid, and there are a number of exchanges where it can be acquired. So I assume that the regulators had a little bit more comfort with that investors aren't going to be left with an interest in a portfolio of entirely illiquid cryptocurrencies. And maybe as time goes on and liquidity improves and exchanges become more regulated, or just the regulators become more comfortable with the exchanges that exist, we could see that expansion.
Our advice to our clients has been to take the high road, that, if you become regulated and you comply, in a sense, you're pulling up the ladder behind you, because the regulators will help you with your competitors by fining them, by jailing them, by whatever. So if you're the only one that's complied, or you're the first one to comply, you have a huge competitive advantage. There was a question over here.
Yes, good morning. Just to go back to the question just before this around secondary markets and being compliant, especially with accredited investors. This is maybe more of a comment than a question, but happy to get your thoughts on it, Daniel. If you're going to be compliant, you get an OM exemption and you sell tokens to accredited investors. One of the things that we're doing is building a protocol right into the token that is a concept of a whitelist. So those tokens, it's an innovation, that the fact that tokens can be coded. So the token becomes smart through the smart contract, such that only accredited investors can buy those. And that's built right into the protocol of the token itself. Could you comment on that? What are your initial thoughts on whether that would satisfy the regulators as it relates to secondary market trading of an OM exempt product?
Or I think it would be a big help. I mean, if you can satisfy them that trades will only happen in and among accredited investors, then I think that removes some of their concerns about or maybe all of their concerns about the tokens getting into the hands of retail investors who can't who can't bear the risk of losing all their money. I mean, that's the benefit of operating in the accredited space, is that these investors are assumed to be able to protect themselves a little bit more than retail investors. And so if you've got a protocol that keeps it within a pool of accredited investors, I think that the regulators would look very favorably on that.
Go ahead.
Okay. So actually, to follow on with that question, would it be possible to satisfy the laws in Ontario if you were to limit it to accredited investors specifically in this jurisdiction, and yet allow for that same token to be traded worldwide without that same restriction?
So in Canada, it
your
is,
ring fence,
you
ring fence Canada, but not the rest.
Right. So my partner Ruben makes a good point that it's not just the location of the investor, but the location of the issuer that is that attracts regulatory scrutiny. So I think that yes. So I think that you might run into trouble with that if you're trying to do it Canada-wide. Might be possible in specific jurisdictions, but I think that regulators would probably also be concerned about it coming back in to Canada if you were to adopt that kind of model.
Hi, thank you very much. So just probably more of a comment, but in terms of just providing some current information. So First Block, obviously popular in the news a lot. They went the route of actually doing a syndicate deal. So they're acting. They're sort of operating as an OTC through CDS. So that was their model. But there are, and yes, they are Bitcoin only. There are two other funds that are just about to come to the market. So one's from Ross Smith in Calgary. The other is 3IQ. And those are both planned to be global cryptocurrency funds. So they're going to have multiple crypto holdings. They're both actually just live on FundServe in the last couple of weeks. Not sure they're actually taking money yet, but I guess my point was just sort of, and particularly when you crossed out the offering memorandum on your slide, I didn't want people to have the impression that there's actually barriers to getting retail distribution. Certainly you're going after higher net worth investors and larger investment amounts, but I think they would have done that anyway. So there is coming very quickly a broad, perspective of different products going through different channels, and they're all hitting IROC. So,
and sorry, these are limited to accredited investors?
Yeah. Yes,
yeah. Okay. And it's very interesting to hear that they're expanding their portfolio holdings beyond just Bitcoin. You're saying? Oh no! I'm just talking about what has been clearly out there. What are the names of the managers? And so, do you know whether those have whether they got terms and conditions attached to their IFM registration?
I don't know that for sure. I would imagine it would be the same as the others. But I know, I guess my point was really these firms are all going after top shelf providers and like legal audit administrators, different channels. So it's coming.
You have the microphone.
Sylvia.
Okay.
Thank you everyone for this informative session. But Alan, I just wanted to ask, you had commented briefly on some of this technology being open source, which, for example, ownership is not really the conversation right now. But as you said, we're getting to the point now where sort of we're seeing the larger iterations of blockchain. Can you comment on the fact that, for example, Ethereum is based in GPL licensing? What would that do for larger corporate entities that are looking to sort of gain ownership in some of these applications? What does that look like moving forward?
Okay, thank you for the question. That's pretty technical. So if we're getting into the open source area.
He's one of mine. I told him not to ask hard questions.
Did you plant that one? No. Look, it starts as open source software, and the licensing is such that enterprises are starting to use this open source software rather freely. Picking on one, Enterprise Ethereum Alliance is a global alliance of companies, enterprises that are using this open source software and building private blockchains with the software. So that brings them into their enterprise space, and Microsoft has it as a blockchain as a service. IBM does Hyperledger as a service, taking these open source softwares and making them available for enterprise private chains, which has not really been part of our discussion today. But I hope that helps you as a starting point. We can certainly talk about the technical details and the fine kind of aspects of that subsequently, and happy to take that offline. Yeah.
Hey, go ahead.
Hi. So I had a question about the pre-sale versus the ICO. What kinds of issues are you seeing that differ between the two, legal issues obviously, not accounting for the SAFT, the Simple Agreement for Future Tokens, because that's obviously what we see in the pre-sale versus the ICO, but are there any other legal issues that you're kind of facing right now where you see kind of a stark difference?
Well, actually, I think that the two, the pre-sale and the SAFT, might have some of the same issues, actually. And this goes back to one of the kind of characteristics that I was talking about tokens and what might make them more or less like securities, and that is the maturity of the platform. So if the funds from the SAFT or the pre-sale are going to be used to build out the platform, then that's a suggestion that the investor is relying on the efforts of others to create value, and accordingly, it might be a security. And so, the SAFT is an interesting one because it's a way to get funding at a time that it's desperately needed. And I know that issuers don't want to be giving up equity in the company, and that's entirely understandable. But it runs the risk of being considered a security because those are kind of foundational funds that are being used to build out the platform. You don't even have the token, and when you get when you get the token, the platform might be built. But if you look at the investment as a whole, then I think that there is an argument that regulators would make that if you look at the investment as a whole, the value that you get out of your token was created by others.
Just for everyone's benefit, because I'm not sure that's a term that maybe people aren't familiar with, a SAFT is sort of based on something called a SAFE, which is a convertible debt type of instrument, stands for Simple Agreement for Equity. SAFT stands for Simple Agreement for a Token. So what they're doing is they're borrowing the money, but it's convertible to a token once the ICO is done. And the prevailing wisdom amongst most professionals and in the states where they've done a lot of these SAFs is that a SAF is a security because you're raising debt. And if you'd done a SAFE, it would have been a security. So doing it for a token, it's likely still a security. The interesting question is, if it is a security, then does that token necessarily become a security when you do the ICO with the system already built? And does it somehow taint and make it a security because it was a security when you issued the SAFT? Does it make it a security when you do the ICO 6 months later? We don't know. Probably is, but we don't know.
Are there any other legal issues that you're kind of seeing between the two?
Well, we've put together a task force of about 20 lawyers from across the country. We have this blockchain task force. They come from virtually every discipline, from tax to tech law to intellectual property, obviously financial services and securities, M&A. We've got a pretty robust group of lawyers looking at issues. Like I said earlier, the tax issues alone are enormous. For example, one of the criteria distinguishing a security from a non-security is the tax treatment. Because if you're pre-selling a token to be used to acquire a good or a service, the use of the token, then presumably when you receive revenue for that, it's income for tax purposes and subject to reserve rights and whatever the local tax jurisdiction and regulations are. So when you raise $100 million, do you pay tax on $100 million when you raise the money? And I think we're seeing people go to low tax jurisdictions like Cayman Islands or Barbados or other places because they are recognizing it as income, but they're paying tax at a much lower rate than you would here in Canada. I mean, that's just one small example. I mean, when you exchange your Ether for currency, for the new token, that trade is a taxable transaction. So the list of issues, we'll be here all day. I mean, literally. Good.
It's a quick question. Is there a plan by for the OSC to introduce a regulated cryptocurrency exchange? A regulated cryptocurrency exchange by the OSC? Is there a plan?
I think that's not their plan. I think that, people who want to operate exchanges are going to have to decide whether they're going to provide a platform for securities or not. If they're not securities, then you don't need to be regulated. But if you are going to trade in securities, it's likely that you're going to have to be regulated. And I think Dan sort of addressed that, but I don't know if you want to add anything.
No, that's exactly right. It would be an exchange operator who goes to the OSC and says, "I want to be regulated," or we don't think we need to be regulated, that kind of thing, and has the discussion with the OSC, and then the OSC makes a decision and helps them become either regulated or not.
Go ahead.
Thanks for the information. I have two questions. One is regarding follow-up on what she asked about pre-sale versus sale and maturity of the product. Generally, in the pre-sale, if it's filled by accredited investor and the product is probably like an MVP stage, does that consider mature? Because generally, Google was not something that is right now in 1997. So what is maturity defined as, if there is a question, if there is any references? And the second is regarding...
But you have to understand, when Google raised its money, it was a security, right? So
That's
true. You're comparing apples and oranges.
Gotcha. Okay, so there are no references around that at the moment, I assume.
No, but and in terms of where the line is drawn on maturity of the platform, that's a very difficult question to answer. I mean, it goes back to whose efforts are creating the value. And so if you have to wait to get any value out of it, that's a sign that it is more towards a security.
Awesome. And the second question is, we believe that blockchain provides a lot of transparency to online gaming industry. Are you looking at online gaming and blockchain as part of that 20 lawyers team that is working on blockchain right now?
I mean, yes, we have clients that are in the gaming space. We also have clients in the blockchain space. I don't think you have to be a specialist in terms of blockchain gaming. I think a lot of the principles are the same. So the answer is yes, and I think there are likely going to be applications. I mean, we can see not only gaming, but video, music, I mean, logistics, tracking, prescriptions and drugs, food source, and I mean the list of things that blockchain can track and disrupt it. I mean, I'm not smart enough to even think of them all.
I would love to chat after the conference.
Gentleman here, I think, has been waving.
First off, I'm hoping you made a mistake. Just backing up a little bit when you said if you sent your Ethereum to some silly token ICO, that would be a taxable transaction.
Yeah,
do you not need to move in and out of fiat?
No. If you bought Ether for $1,
right,
and it's worth $600 today, and you exchange that Ether for kin, that's a taxable transaction. And you're going to pay tax on the difference between $1 and $600.
Because it's capital gains, is it not?
Depends on the taxpayer. If you're a trader,
yeah,
it could be income. If you're a one-off investor, it might be considered a capital gain. There's a lot of taxable transactions that are out there.
You're giving me nightmares now.
We can go on. We could be here. I could scare the crap out of you.
I think the fundamental response is that not only do you need legal advice, you need financial advice. I mean, there's to be aware of the tax implications. So, on a financial basis, there's a lot of the CPA community is rallying around this because they know there's lots of questions, just as there are legal questions here.
Right, well, I need to get more guidance, I guess, but I'll pass the mic.
So my question's for Alan and for yourself, Jeff. So is the TokenFunder, is that considered a security? Is that where, or is that something you can't?
It will be. It will be. That's the way we've gone this route because we want investment to happen in Canada. We want the flight of capital to happen within Canada, and we want capital to come into Canada, and we want it to deliver high-quality investment opportunities. So, that's the reason for going the regulatory securities route.
And so are you restricted then of what type of capital the different countries that can invest in that? Like, is that?
Yeah, there's only so much I'm afraid I can't say about the details today, but very soon we'll be able to share details with
Again,
you.
the basic principle is you're looking at where the investor resides.
Mm-hmm.
So if you're going to sell to an investor in Ontario, you've got to comply with Ontario securities laws. If you sell to an investor in the U.S., SEC. China has its regulations and so on. So when you're issuing tokens, you have to look at where those investors are. Now, most of them haven't looked thus far because it flew under the radar. You know, they did these deals in 30 seconds, 15 minutes. It's very hard to see who the investors are. I mean, truth be told, it's not transparent in that sense. So the regulators don't really know until they go and something bad happens and then they do an investigation.
So are there any ICOs that are out there that do attract global money properly where they know it can be? Because a lot of the ones I've seen block U.S. Citizens out, block Canadian citizens out. So I'm I'm in the process now of trying to understand that aspect of it because I want to be able to attract global investors, and I don't know what the proper way to do it is.
Yeah, as you've just alluded, and I'm super deep in the space. The fact that they don't know. Read the terms and conditions, those cookie cutter terms and conditions. Frankly, as I refer to them with the Swiss ICOs, they do say if you're a U.S. resident, you should not be doing this. Great, then it's on you. But they also have no clue. They actually don't know if you're a U.S. resident contributing to this. And then what they're trying to protect themselves from, not being a lawyer, I'm just an honorary lawyer, but I've now been schooled in that, they're trying to protect themselves by saying you shouldn't be arising. Yeah. But if a U.S. citizen then were to participate because they're essentially allowed to, and look, this is not the kind of quality that, we're so early in the space that, a lot of this is buyer beware today, and people are going to get hurt. They're going to go complain to their regulators. That complaint starts a process. And again, I'm not the lawyer or the regulator on the panel, but this is important as an entrepreneur getting into the space that that there's a lot of concerns you should be aware of in taking people's money and taking it from around the world. No question about it.
Sorry, one other comment I would like to make, and we've had a parade of people come see us in the last, 4 months or so who want to do ICOs and so on. The level of awareness and understanding is hugely diverse. Some people are very technically aware, understand it, get it, know about blockchain, understand what's going on. There's people who see this huge amount of money that's being raised. They read the headlines and figure out, oh, this is a new way to raise capital. But they haven't made the connection between cryptocurrency and blockchain. They're offering tokens, but there's no there. And they don't understand. So if one thing, like anybody who's not sort of in the space and wants to take one important thing away, the two are really connected. That's the fundamental thing. And there are a lot of people, surprisingly, who don't appreciate that. Because we've had people come in and say, I want to issue tokens. And we'd say, well, what blockchain application? Well, what's blockchain? So and I'm not trying to be, difficult about it, but, it's a fundamental thing.
So one of the question for you was, so I'm in the process trying to, the technology project's already in place, demo, everything, that side is done. The thing that's holding us up is the understanding on the legal side of things. Americans, Canadians, then you know what, forget it, let's go to Thailand and do this, right? So, but then I think I'm not mortgaging my house to be able to try to help pioneer some of the legislation. So where's that process for companies that, because it's so new, it's so uncertain, even if I did get advice here, it would change anyhow because the space is changing so much, right? And
well, I think Alan's approach is the approach. You go and talk to the regulators, and they will walk you through the process. It'll take you months, but at least when you come out the other end, you'll have some comfort to know that they're not, they're your friends. They're not your enemies.
I have a lot of friends that have just said, we're going to spark up an ICO, and they have no clue about any of the legal, any of the financial. It's risky. I mean, being an entrepreneur is being risky in the first place. Now, this is added risk, and the regulators are there to support this process. I mean, back to timing, I mean, you have to be aware that it takes time, it takes effort, it takes understanding to know the laws of this land, at least. Sure, go to another land, go to another jurisdiction and run it there and use those regulations. But we have a process here. We have, by the way, we have a solid, credible, world-leading, stable economy so far. Knock wood, right? And there are reasons for that.
And you may end up in a different jurisdiction as well because of the tax implications, right? So you may decide to do part of your offering here and part of it in a low-tax jurisdiction because of the tax implications of, as I talked about earlier, in terms of how you treat the crowd sale for tax purposes. If you're raising $100 million and you do it in Barbados, it's a lot lower tax rate. More questions? Okay, shoot.
For Mr. Christensen at the end there, I can attest to the veracity of what you were saying about regulation. I buy and sell Bitcoin over the counter, and I've maxed out my bank account. They don't want any more of my money in there coming from Bitcoin. They heard the word Bitcoin, they hiked their skirts, and I'm lucky it's a credit union, actually, so I still have my account. But I guess getting to the question is, do you have any advice for people who have to use the word Bitcoin when looking for financial services and finding themselves on the street? Because I'm not alone in this. I know it's a big problem, and I must commend Canada. Regulatorily speaking, it seems like we're on the right page. The light touch. It's all good. It's all go, except traditional banking services, and we know they're terrified of cryptocurrency, and they're making their end-run play around it. And in the meantime, all of those of us who are on the forefront, it's a bit like legal pot. All the guys that were growing are in jail, and now Justin's friends are all running the show. So the same thing is happening, and I can say these things. And then, and so the same thing is happening with Bitcoin. I'm kind of stuck in the middle now, and I'm trying to talk with my credit union's compliance department. I'm pretty sure I'll be able to escalate to the phase where somebody in compliance will actually talk to me. But long question short, any advice for people like me kind of stuck in the middle there?
Yeah, I guess I have a couple thoughts there. So first of all, I think it is a challenge. I don't think there's any sort of easy way through it. I think there's a couple different. I make two comments, right? So number one, I think there are people that are in businesses that, if the financial institution understands it, is a genuine concern to the financial institution. So if someone's in a business where they are dealing with counterparties that they don't know, and money's coming in and they don't know where it's coming from, and then they're going to their bank or credit union and saying, "Hey, I'd like to give you this money," that's a legitimate concern on the part of the financial institution, right? They have to deal with their regulators. Right? They have to deal with reputational risk, and they're just not going to do it. It's just way too risky.
Well, plus this is going to take them down, right? Like this whole blockchain revolution has a potential competitive
disintermediate the entire.
Correct. So they're not likely to want to encourage that.
No, that's right. It's like I said. There's this little game that is being played right now where the banks say, "Oh, well, there isn't quite the we're uncomfortable with the lack of regulation," but I mean, come on. If they wanted that regulation to be clear, it would be, and I think it mostly is. The only.
But the other thing I think there were some people who are engaged in activities that, if the financial institution understood them, it wouldn't really be a concern, right? So I think there can be businesses that you're in that are related to blockchain or cryptocurrency that don't involve getting money from people you don't know. They just involve you doing certain things in the world that relate to this, right? So, for example, if someone bought some Bitcoin and sold it, that's not necessarily that may or may not be a concern if they understand it. But I mean, the challenge is going to be getting the attention of someone who is a decision maker at the financial institution to say, "Hey, can I explain to you what my business model is?" Maybe there's controls that are in place to mitigate some of these concerns, and if you can explain that, maybe the person will understand. But getting in front of someone to do this is not the easiest thing when there's just these red flags like, "Oh, cryptocurrency, blockchain, let's just stay away from it," right? So, the only real thought I have there, and I don't know if this is going to be particularly helpful to you, is I think it can be helpful to deal with smaller financial institutions where it might be more worth their while you're dealing with a credit union already. You're not dealing with one of the big banks, so I don't know if that's necessarily the right avenue. But in general, I think that it is easier to get attention with smaller financial institutions than some of the large ones, and and some of them also might be looking for ways to, new kind of new ways to attract deposits, et cetera. Like they might have more of an appetite for that than some of the larger
I
financial
actually
institutions.
suggested to the people at Alterna, I'll mention them, I don't know if anybody's here, but I told them about this conference and that I'd be here and they should show up and hand out business cards and look like they were at least thinking about things. I don't know if they did. But anyway, thank you very much.
Well, I think we're going to have to wrap it up because we're 10 minutes over time. So we'll stick around if anybody has some additional questions. But I want to thank our panel. I'd like to thank you all for coming. I'd like to thank Kaylee Zimmerman and Andrea Tulloch and Nick Fan. They pulled this together. They organized this webinar and made it all happen. When we do these early morning things, we're lucky to get 10 or 15 people with bleary eyes out. We had over 600 people register for this. So kudos to our staff. Thank you. And thank you.